Okay, next this afternoon we're going to hear from Dr. Stephen Webster. He's their Director and Principal Consultant at Tautenay. So welcome.
Thank you very much. Good afternoon, ladies and gentlemen. I'm going to start with an apology. You've had lots of exciting talks, lots of interesting talks. I'm going to talk about EU regulations. So I apologise, it's not the most exciting topic. I'm going to say also, though, it's a very important topic. It's going to be very relevant over the next couple of years. So the exact title of the talk is the UK-EU SPS agreement and what this could mean for Jersey. For those of you who don't know, the UK-EU SPS agreement is about to be negotiated between the UK and the EU, and it could have direct impacts upon us here. Okay, so what I'll talk through, and it does get quite technical at times, so I apologise again. I'm going to give an overview of a document called A Common Understanding. We'll talk about the post-Brexit challenges to trade, features of this agreement that are in the public domain that we already know about. I want to talk about some of the benefits of being involved in the agreement, some of the consequences of non-involvement, and then the critical issues and the priorities as we go forwards. So, starting with A Common Understanding. This was the name of the document published jointly by the EU and by the UK on the 19th of May this year. It actually covered a whole range of areas. It wasn't simply the SPS agreement, so security and defence, health security, youth movement, etc. The most difficult part of this, the bit that requires the most negotiation, the bit that will impact on trade most and impact daily on people's lives most, is the common SPS area. So that is now being developed. It is being, the EU is putting forward its own mandate for what it wants to achieve from this. The UK has been doing the same and deciding what it wants to achieve from it too. But this document set out some of the key areas that we know about already. So the wording, by the way, is very precise. So I haven't rephrased this. I have actually split the sentence up so it was understandable slightly. But the wording is very precise, and it's precise for a reason. It's because it's written by the European Commission and by UK government as well. And they have to be very accurate in what they're saying they're going to throw into the negotiation, what's up for discussion. So if it's not in here, it's doubtful whether it's going to be included. If it is in here, it's there for discussion, it's there for negotiation. Nothing is definite yet. So the wording is sanitary and phytosanitary, so that's essentially, from our purposes, animal and plant health. Food safety, general consumer protection rules applicable to the production, distribution and consumption of agri-food products. So essentially what you do. It's applicable to the regulation of live animals and pesticides. The rules on organics and marketing standards applicable to certain sectors or products, not defined. But we know roughly what the EU regulations are, so we can start targeting ourselves as to what we think this might mean. And it was made quite clear in the separate EU paper, separate to the Common Understanding. There was another paper published by the EU clarifying their position, and that included certification and official controls. It was alluded to in the Common Understanding paper, but it was made clear later on. So, a quick thought on post-Brexit challenges to trade. Pre-Brexit, Jersey, Guernsey and the Isle of Man were subject to something called Protocol 3. Protocol 3 gave us an advantageous position. It meant that if we were importing goods or exporting them to the EU, we had to apply EU regulations. If we weren't exporting to the EU and we weren't importing, we could do what we want. So for domestic production, for domestic consumption, we could do anything. It didn't matter. We did tend to follow EU regulations, but it wasn't absolutely down the line that we had to. Post-Brexit, we have a couple of important documents. The most important is the Trade and Cooperation Agreement, the TCA, and that defines the territorial scope of what we can actually do with the EU and why we can do it. Jersey, separately to that, is listed as a third country to the EU, so listed by the EU as a third country for imports, so imports to the EU. Post-Brexit, any trade into the EU of agri-food products has to be notified, certified, inspected at a BCP. And many of you will have found this if you are exporting. It suddenly becomes quite hard. And then there's a particular issue trade into Northern Ireland is treated as triangular trade. My personal view is that that treatment is because somebody didn't read the Trade and Cooperation Agreement, and it's a poor interpretation. But nevertheless, it has caused issues in terms of trade into Northern Ireland from the Channel Islands, because that trade has to go through the UK. It goes into the GB, into Northern Ireland. So that's regarded as triangular trade, and it causes issues. So post-Brexit trade with the UK, which includes Northern Ireland really, but I'll put it in the EU box for the moment. Post-Brexit with the UK, trade is unchanged, provided Jersey applies UK border operating models to its imports from the EU. So provided we comply with what the UK says we should be doing for imports from the EU, then trade to the UK should remain pretty well the same. Post-Brexit trade with the trade from the EU, therefore, has to be notified, certified, inspected at a BCP coming into Guernsey. So just to explain that slightly, if we look at who decides on the trade rules, it's always the importing country. So for the EU, they decide on the trade rules for imports there. UK decides on the trade rules for imports to the UK. We decide on the trade rules for any goods coming into Jersey. So that's very much our decision. But essentially, we want to minimise friction for some of our exports at least, and the decision was made a few years ago that most of our exports going into the UK, that's where we want to minimise friction. So we apply UK rules for goods coming in from the EU in order that we have minimal trade friction for goods coming out and going into the UK. It makes perfect sense. However, we do end up with different sets of rules for different directions of travel. So that was the issue one of the issues that's being dealt with potentially by the SPS agreement. A few things we need to know about the agreement. I'm trying to go through this quite quickly because I know it's very, very sort of academic and I don't have many pictures. So features of the SPS agreement. First of all, it may be extended to the Crown dependencies. It doesn't have to be. It's not written in stone. But it may be extended to the Crown dependencies. It requires something called dynamic alignment. So this means the timely, or effectively immediate application of in-scope EU rules. So essentially, we become a rule taker from the EU, we apply all their rules. It does provide for some limited exceptions to the application of EU rules. They're most likely going to relate to things that the UK has advanced on since post-Brexit. So I would imagine we'd be looking at things such as gene editing at that point, where there's a slight difference in regulations between the two parties. They're heading in the same direction, but it would be pointless in bringing one of those parties back before going forwards. It's subject to the dispute resolution mechanism, so there would be a direct dispute resolution mechanism between the EU and the UK. The Court of Justice of the European Union is the ultimate authority. Okay, so any issues, ultimately it's the Court of Justice of the European Union who would be the deciding body for any issues between the two parties. That actually has a positive advantage to us in that the CJ-EU, essentially it's technical, it takes it out of the political. Anything before that is it's a mix of technical and political. CJ-EU, the Court of Justice, they decide technically what is right and what is wrong, what is complying with EU regulations, what isn't. So potentially a benefit to us. I've put here, the UK will be treated for the application of all these EU regulations as if it were a member state of the European Union. Jersey will be treated as if part of that member state. I'm not quite sure exactly what that relationship will be. It's not part of this negotiation. That's a separate discussion between Jersey and the UK to say what is that relationship. But essentially, from an EU perspective, we will be part of the UK party. And I think, and I don't know this for sure, but we're sort of guessing, there's an EFTA states mechanism. So if you go to the Northern European states, Norway, etc., the mechanism they have for aligning with EU regulations would likely be the same as the one provided to the UK. So you can actually shape the regulations, you get to see them beforehand, you get to actually input into those regulations. You're not a member state, so you're not voting on them, but you are actually beginning to shape those developing EU regulations. So, benefits for businesses. If you're exporting to the EU, then there's no longer any requirement for third country listing, no requirements for entry through a border control post, no requirements for notification, pre-notification or inspection. Health certification for products of animal origin would no longer be required. There is still some health certification for movement across borders for live animals, so that does still exist to an extent. No triangular trade issues for agri-food products moved to the EU or Northern Ireland through GB. So lots of benefits of trade, which are positive, I would suggest. For imports from the EU, we would no longer have the requirement to follow the UK's border operating model. So essentially, we open up to a pre-Brexit type situation of relatively free movement of goods. We have to think not only of benefits and disbenefits to agriculture, we also need to think of the public impact of these changes. So, just a couple of the things. So, foods would more easily be imported from the EU by retailers and by wholesalers, with hopefully a positive impact on food security and resilience. Personal allowances, the food that you can carry as a passenger, on journeys to the UK and into the EU would be unrestricted and unlimited, we assume. This is assuming that, as the EU put out in their initial statement, official controls are included. And we would hope that we'd also see easier movement of horses and pets to and from France. On pets, this is an excuse for me to put a picture of a ferret up, because I like ferrets and we don't see them up enough. Pets, in terms of the EU and what the EU thinks, the regulations apply particularly to dogs, cats, and ferrets. And I've never quite understood it. I'll ask Susanna later why ferrets are so important here. So there is a specific regulation laying down the animal health requirements applicable to non-commercial movement of pet animals, and for the checks on those movements. This is the regulation of live animals, so I think it is in scope. We don't know, but I think it will be in scope. If you're going into the EU from a third country, you require a health certificate, rabies antibody titration test, unless that's negotiated away, and you need to go through a traveller's point of entry. It's a hassle. If, on the other hand, you're going from member state to member state, as we will be doing under this agreement, you require a pet passport. You're basically reverting to the previous state of affairs, the pre-Brexit state of affairs. So we can see advantages to the public in terms of pet movements, in terms of personal allowances. Travel to and from France becomes more straightforward. So if the agreement isn't extended, so looking at the opposite direction, we remain a third country. We have the existing barriers to trade. We have no access to EU surveillance and monitoring of diseases, so there's another issue there. Restrictions on personal allowances remain as current. Exports to the UK would potentially be treated as exports to the EU. And when I say potentially, I believe they would be treated as exports to the EU. Otherwise, the UK has to negotiate with the EU that it has a back door into the EU, and I don't see that happening. There is a positive here. Imports from the EU and from the UK, we would have the absolute freedom to restrict, de-restrict, etc., what those imports are, provided we were compliant with World Trade Organization rules. So we could do what we want in terms of imports, but for exports, it's slightly more challenging. And to put that just in a picture, if the SPS agreement isn't extended to Jersey, trade rules are maximised. All trade is treated as movement across an international border. So possibly not a good thing. Okay, so if the SPS agreement is extended to Jersey, if we are part of it, a couple of things we need to be aware of. So first of all, we reduce our ability to autonomously control the movement of agri-food goods into Jersey. We can't simply do what we want. We have to do things as though we were a member state of the EU. So we're restricted in the tools we have for protecting ourselves from imports or from diseases, etc. There's a word here that ACQUIS, which the lawyers always pronounce ACI. It's useful to know if you're ever playing Scrabble. The only other time you'll ever come across it really is in these negotiations. What it means is it's not just the in-scope regulations and laws, it's all the body of law that sits behind those. Every court judgment on those laws that has been in the past, all the court decisions, etc. So it's called the EU Acquis, and this is the only time, other than a game of Scrabble, where you can impress people that you're likely to hear it. So adoption of that could result in regulatory changes, particularly for domestically focused businesses. Export-focused businesses will already be compliant, 99.9%, with EU regulations. But for domestically focused businesses, there are changes which are likely to happen. Again, looking at it pictorially, if the SPS agreement is extended to Jersey, trade rules are actually minimised. All trade is treated as internal movements within the EU. So it becomes a bit more straightforward in that way. So, critical issues, priorities. There's a challenge to the government of Jersey, and this is the same challenges to Guernsey and to the Isle of Man. We have ways of protecting the biosecurity for our key industries, which have been in place for a long time. We have to look at those and say, are they still compliant? Can we still keep them? How do we actually achieve the same biosecurity for our key industries within the EU regulatory framework? So that's the challenge to government, and it's one of which I know they're very alert to. There are challenges to businesses as well, and two separate challenges, really. Changes to the regulations on imports and exports of agri-food goods present risks in terms of competition and opportunities in terms of market access. How do we actually take those opportunities up? How do we make the most out of this? Also, changes to the regulations on production and marketing may require a change of approach. I'm going to give a couple of examples on this. They're sort of nuanced. You think actually there's got to be a massive change. It ends up being a minor change, but it's the changes that we need to know about if we're going to actually be compliant, if the agreement does eventually apply to us. So, eggs was the first choice. I don't have any photographs of eggs, and I couldn't go online and get photographs of eggs because they're all EU-type eggs or UK-type eggs, and they're all marked as such. And I thought, no, that would be wrong. It's the wrong image. So this is just a random hen. Under Protocol 3, no requirement to apply EU legislation with respect to production and marketing. So if this specific legislation is in scope, 1308/2013, it's a particular piece of legislation, then detailed rules on marketing standards, definitions, designations, and sales descriptions will apply to domestic production for domestic consumption. And these include those under the separate regulation regarding the marketing standards for eggs. When you look into these, you think, oh my, this is going to be terrible. And then you look again and think, actually, it's probably not that bad. So principal changes relate to quality, weight grading. Producer marking of eggs. You would have to produce and mark your eggs which are on sale to the public. So that becomes down the line. You're not allowed to sell unmarked eggs. You have to mark your packs in a particular way. And that very much relates to the definitions of farming methods. You would have to use the agreed definitions of farming methods for barn eggs, free-range eggs, etc. And you can't diverge from those. There are derogations, and generally within EU regulations, for a lot of these marketing-type regulations, there are derogations for direct sales, derogations for smaller producers. So here there are derogations for sales which are direct to consumers, and derogations to flocks of fewer than 50 birds. So if you have a very small flock just at the farm gate doing something, you can do something slightly different. But otherwise, you will be in scope. Similarly, it's the same regulations. So cider, I thought it's worth talking about cider, seeing as where we are. Under Protocol 3, no requirement to apply EU legislation with respect to the production and marketing of cider. You'll be pleased to know that at the moment there is no EU regulation for the production and marketing of cider. I think you could actually put an apple in a glass of lemonade, call it cider, and you wouldn't be breaking any regulation anywhere. So, why do I mention it? Well, it's because it is actually in discussion. It's in discussion at the moment in the EU. The European Commission is in favour of establishing an EU marketing standard for cider and perry, with a preference for detailed rules complemented by optional reserved terms. One of the rules here will be on how much apple needs to go into your cider. And if you look at the responses to this particular consultation that the EU did, you have the as it were the bulk cider makers, the very big producers producing tins of whatever, which appears to be cider, very fizzy, and they would be saying actually we want a very low percentage of apples because we can supplement it with maple syrup and everything else. If you look at the responses of the Normandy farmers and the Normandy cider producers, actually 100% apples is what they want. You know, make cider mean cider. And I think the European Commission has come out roughly halfway through. They've said, you know, a minimum of 50% apples, but then putting in some optional reserve terms. And what these are terms that you can only use if you actually comply with their definitions. So if you want to call your, say that your cider is some pure fresh juice, it has to be from 100% apples, or if it's perry, from pears. If you want to call it farmhouse, it has to be processed on farm using 100% apples. If you want to call it craft, that would be pure fresh juice and no industrial processes, no overpressing. And if you want to say it has natural effervescence, it means it only has bubbles from fermentation. So a very precise set of terms. And again, we have to look at whether or not they impact on Jersey. They probably do, in that they reduce some of that competition from external cider, which isn't cider, because all our cider is actually made as farmhouse craft, natural effervescence cider. So we're actually in a good place, and again, there's an advantage there. So they're just two examples, eggs, cider. We have to look at everything that we make across the board to just double check that there isn't going to be an impact on the ground, and hopefully that the impact would be positive. If I say thank you, I'm happy to answer any questions over a glass of something craft farmhouse, and ideally made from 100% Jersey apples. Thank you.
Well, I can't offer you cider, but I can come back with some questions. Here we go. The UK Labour Party has ruled out accepting the direct jurisdiction or control of the Court of Justice of the European Union. So is this all pre-Brexit fantasy?
I'm going to avoid the politics, if you don't mind. Okay. The UK has stated everything that was in the presentation there, so that's just taking what's in the public domain. They have stated within the common understanding that the Court of Justice of the European Union would be the final arbiter. That said, I mean, if you're thinking politically, the UK can always opt out of the agreement as well. So there are other political ways, directions on the way. So I'm going to avoid answering directly, though, whether it's a post or pre-Brexit fantasy.
Fair enough. Timescales, negotiating and introducing the agreement.
Okay. We think, roughly, and this is really based on how we think the different parties will benefit, we think the UK will want it in place in 2027 or thereabouts. So there are advantages to the public in terms of food resilience, food security, avoiding empty food shelves, and they will want to see them in place most likely well before the next UK election. So we can see that they'll want to do it fairly quickly.
Someone's saying that they believe that the Trade and Cooperation Agreement has been a failure for Jersey. Is it time for the island to define its own trading relationship with the EU? I think you mentioned that you didn't see that happening in your talk.
But yeah, we are not responsible for our own international relations. We do things through the UK. I don't know whether the Trade and Cooperation Agreement has been a failure for Jersey. It's been a very peculiar time with, and it was mentioned earlier, invasion of Ukraine and various other things happening. It's been a chaotic period in agriculture and food production throughout. So I don't know whether I could say it has been a failure for Jersey. Defining our own trading relationships with the EU is quite hard, would require a lot of capital from government, as it were, and would also set us aside from the UK, which is a major trading partner. So it would be lovely, but I don't think it would show any advantage in the long term.
Okay, last question. Will the SPS agreement include geographical indicators? And if so, is there anything here that we could be taking advantage of?
We don't know whether it will include geographical indicators. Given that it will include some marketing standards, the likelihood is yes. And again, I think it's been mentioned today on more than one occasion, Jersey has a fantastic brand. The more we can use things such as geographical indicators, the more we can defend that brand in the public and in that particular market. So, yes.
Dr. Stephen Webster, thank you very much indeed.
Lovely. Thank you.